Local attorney Randy Reep joins me now here on the morning show for a look at and now analyzing what happened in the courtroom. And Randy, the intersection of race and law enforcement has long been contentious here in the United States. And this case is bringing about a call for wider justice. Do you think, given the verdict that was handed down and given the reaction, the door is now open?
It certainly is more open than it used to be. And I'd argue not only is the trend in that direction, but the presence of cell phone cameras and body-worn cameras on the part of law enforcement is certainly going to move that even further in a progressive position.
Now, Chauvin does have the right to appeal. Did you see anything in the course of proceedings that may be grounds for that appeal?
Certainly the moving the venue, that's obviously something that they'll work on. We didn't see every objection and how it was ruled even pre-trial, but certainly there will be a number of appeals. And the publicity even during the trial, as I think you'll talk about, is problematic, I think, in a reviewable issue.
Let's broach that question. At one point, even the judge said this might be a course for appeal. Representative Maxine Waters said the unacceptability of anything less than a murder conviction and talk about being confrontational. This was the judge's response. I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned. Can anything come of that?
I think absolutely. I mean, it's very problematic. You have to think of community leaders in their leadership position. Those are actually calls for people to do things by their elected leaders. This wasn't explaining how the process works or trying to inform people of what is going on. This was calling for an action in the middle of a deliberation. And I think uniformly in the legal world, that's not something that's particularly helpful to the non-prejudicial effect of a trial.
Now, during the course of the prosecution's offering its side of the story, much was made of Chauvin's indifference when he was kneeling on George Floyd's back and neck for more than 9 minutes. And even during the course of the trial, he seemed to be indifferent. And it was really hard to tell because he was wearing a mask, so you couldn't see some of his emotional reaction. It didn't appear that he had much emotional reaction during the reading of the verdict. So that said, would you have put him on the stand? Because it would have been his chance to take the mask off and maybe gain some sympathy from the jury.
I'm a defense practitioner, and that moment to put a defendant on the stand is his call, but to do it is wrought with great danger. And what we're going to talk about later is the aggravating factors might have been enhanced by hearing his explanation of things. So I think letting the evidence lie, I certainly wouldn't find fault with making the state prove their case without him testifying. And his indifference is something the jury instruction says you can't give him any credit to that one way or the other for his lack of testifying.
And as far as the sentence that may be handed down in about 8 weeks or perhaps longer, depending what happens, there's something that they use in Minnesota called Blakely evidence. So they would use the most stringent charge as a guideline, which would be 12.5 years if that comes into play. The judge does have the latitude to go ahead and impose a lengthier sentence. Where might this fall?
So that to get there, the presumptive sentence, as they call it in Minnesota's appears, 12.5 years, up to 40 years. There's mitigating and aggravating factors, and there's 3 aggravating factors that are going to be brought forward. What's very interesting is Chauvin had the right to have the jury find those beyond a reasonable doubt. He waived that and left it up to the judge, and that's probably interesting. You and I were talking off about how long the deliberations were. I think it was clear the jury had found what they needed to find on Chauvin. I think he's hoping to get a better answer from the judge on those aggravating factors and rely on the fact that he has no criminal history to be closer to that presumptive sentence. But the judge, I think, will find those factors likely and probably move that up from the 12.5 years.
Maybe to something in between that and the 40 years, like 20.
I wouldn't put a time to it, but I'll say it's very reasonable to see that land between 12.5 and 40, and 20 seems to be in the sweet spot there. We'll see. I mean, I have no idea until the arguments are made, but that's likely.
We should know in about 2 months' time. Randy, thanks for being here. Appreciate it.